Hi, everyone. So we are here for this webinar, No Surprise Bills Act. The reason I put this together, my name, by the way, is Pinky Pascasio, and I know many of you already know me. I've been getting a lot of calls, a lot of questions from most of our clients. So this is the very reason I brought this together. Miss Gina Campanella is a brilliant healthcare attorney who's, I think, has more authority to speak about this No Surprise Bills Act. So Miss Gina, take it away. Thank you.
Thank you so much, Pinky, and good morning, everybody. Thank you for being here. I was so happy when Pinky asked me if I could put together a presentation on this new federal law. Pinky and I have been working together for many years with common clients. As many of you likely know, Pinky is one of the top billing and coding consultants and experts in the country. And I was very lucky to get to meet her several years ago and be able to recommend her and work with her on many of our common clients. For those of you that don't know me, my name is Gina Campanella and my firm is Campanella Law Office. My main office is in Northern New Jersey, but I work in New York, New Jersey, Pennsylvania. I'm also licensed in Vermont and the District of Columbia. But today's subject matter is federal law. So wherever you are sitting, whatever state you're joining us from, this does apply to you. So a little bit about me. I am a graduate of Seton Hall University School of Law. I also have a master's in healthcare administration, also from Seton Hall School of Health and Medical Sciences, where I am presently an adjunct professor for that program. I am recognized as a Super Lawyers Rising Star through 2020, and this year also a super lawyer and a top 100 attorneys in America. So in addition to my qualifications as an attorney, I am also a certified HIPAA administrator, and I have my certification in social media marketing. So my practice focuses on business law, but with a very strong emphasis on healthcare businesses. And that's where I find a lot of my physician and provider clients really need assistance. Healthcare is unfortunately a business. It's no longer hanging a shingle and just taking care of your patients. And there are a lot of regulatory compliance issues that you do need to be aware of. Now, in addition to the federal Stark and anti-kickback laws and fraud acts and all of those things that we've all had for years, we now have the Federal No Surprise Act. And I will get into speaking about that now. We will have plenty of time. We will have a half hour for questions and answers built into the end of this presentation. So please, if you have any questions or answers, just go ahead and type them into the Q&A or the chat box. And then at about 11 o'clock, I will open that up and start answering questions. And I'll also provide all of my contact information if you have questions you'd like to ask me offline at the end of the presentation. So what is this, right? Where did it come from? It's been in the works for quite some time, but a lot of people are just finding out about it or just finding that it's applicable to them, which is why I felt it was really important when Pinky said to me, look, my clients who are medical practices and ambulatory surgical centers need to know how this applies to them, because we all know it applies to hospitals, right? So this was passed as part of the Consolidated Appropriations Act of 2021. This particular part of the Consolidated Appropriations Act, it was established with the sole purpose of protecting patients on a federal level from surprise medical bills. Okay, it does apply to insured and uninsured. Okay, so this is not just a matter of we are protecting people who have insurance from being taken advantage of by an out-of-network provider. We are also protecting the uninsured in this scenario and with this bill. And it is applicable to any and all services that are provided on or after January 1st of 2022. A question I've been getting from a lot of my clients who I have been assisting in implementing this statute is, do I have to give this to all of my current patients, or is this just going forward for new patients? And unfortunately, it's something that you do have to provide to all of your patients. whether they are continuing care, current patients, or they are new patients. So this is not something like, for example, if HIPAA were updated and we had new notice of privacy practices, you would just have to give it to new patients. This is across the board applicable to everyone. So I like to mention that now at the top of the presentation, because I think that may frame how you're listening to what I have to say, and how you're taking notes and internalizing how this will affect you and your practice. So what about state laws? Okay, I've gotten this question a lot because New York has in particular has had a similar no surprise bills law in place to protect New York consumers. And I've come across several people who are in New York who think that they do not have to change anything because they are compliant with the New York law. This law, from what I've been seeing so far, does have some things that are more restrictive than the New York law. So even if you are sitting in a state that already had state laws with similar protections, you do want to check and make sure you're compliant with the federal law. Okay, because the way the laws work is federal laws can be more restrictive, or state laws rather can be more restrictive, but they cannot be less restrictive than federal law. So the easy way to say this is if you are sitting in a state where there are existing state laws that are less restrictive than the No Surprise Bills Act, this federal law now applies to you and you must become more restrictive to comply with it. If you're sitting in a state where there are existing state laws that are more restrictive, well, this federal law still applies to you, but you likely aren't going to have to change anything. You're likely doing everything that you need to do, but you still want to check because there may be different notice requirements and there may be different documentation requirements. Okay, so the big question, who is included? Who is covered by this law? Okay, anyone who has insurance through a group health plan is covered by this law. Anyone who has group or individual health insurance, okay, so people who have their insurance through the exchange, people who privately buy their insurance, federal employee health benefit plans, and the uninsured. Okay, and that's critical. It's a huge question I've been getting over and over again. The uninsured are protected by this law. Who is not included? Individuals who are covered by Medicare, Medicaid, Indian Health Services, Veterans Affairs Healthcare, which is our veteran healthcare system, and TRICARE, which is our active duty military healthcare system. Why are these people not included, right? It would seem that these are the people we would want to protect the most. Our retired persons, our disabled persons, the poor, Native Americans, our veterans, our soldiers. Well, it's very simple. These people are not included under this law because there are already equivalent or more restrictive laws in place that protect individuals who are covered by these programs. So if you have a Medicare practice, a Medicaid practice, if you work at the VA, or you primarily serve TRICARE, you don't necessarily have to worry about this law for that patient base, but you should be aware that there are already substantially similar laws that protect these individuals. Okay, so what is required? The meat and potatoes of this law. This law essentially puts significant prohibitions on balance billing in certain instances. You must disclose these balance billing protections to your patients. You have to give complete transparency of healthcare costs. There are protections for individuals who require continuity of care. And then there are also new provider directory requirements that have been imposed on the third-party payers. So for our purposes today, I'm not going to get into the provider directory requirements because this presentation is focusing on how this affects all of you as medical providers or ambulatory surgical center owners or investors or providers at ambulatory surgical centers. So just know that there are new provider directory requirements. So if you do get requests from your third-party payers for updated information or anything like that, that's very typically where it's coming from. Now, before we move on from this point, I do just want to clarify what balance billing is, okay? I have had a lot of clients say, well, listen, I'm out of network. I'm completely cash pay. I do not balance bill. Why does this apply to me? It applies to you because your patients may or may not be uninsured, or your patients may or may not have insurance coverage where they could potentially be choosing to see someone in network and saving a significant amount of money. Okay, so that is why this applies to you, even though you're not physically billing insurance, collecting the out-of-network rate, and then balance billing your client. Accepting a full cash payment up front counts, okay? Because then your patients have the opportunity to submit and try to collect their out-of-network benefits, or they're simply treating themselves as if they're uninsured and cash pay, which we already learned this applies to them. Okay, so what is the restrictions on balance billing? Who do they apply to? They apply to all providers and facilities. We know they obviously apply to hospitals, okay? The real motivation behind this bill was to prevent the situation where somebody goes into the emergency room and they're getting treated in the emergency room, and all of a sudden they're getting bills from out-of-network anesthesia providers, out-of-network orthopedic surgeons, out-of-network, emergency physician groups, what have you. Okay, so that was really the motivation behind this bill. And as I've told a lot of people, anyone who works with me knows I'm not shy about what laws I do and don't like. I don't hate this bill. Okay, I really don't. I think it was, from a public policy perspective, it's very important and it's very critical that we have something like this to protect the most vulnerable in our population. However, I do not like how it's being applied to medical practices. I have a significant portion of my clients are in the mental health space, and I am fearful for the chilling effect that it will have on individuals seeking mental health care treatment. So it's definitely, it had very good intentions, and most of the bill I think is very good, but unfortunately I think we need to have some updates for it to be perfect and for me to be very comfortable with it. So that said, it applies to all providers and facilities, including all medical practices and ambulatory surgical centers. And there are enumerated requirements for facilities and providers. This is especially critical if you are an out-of-network provider at an in-network facility. This is probably the most complicated situation that's governed by this bill. So what kind of balance billing is strictly prohibited? There is absolutely no balance billing permitted for any emergency services that may be provided by out-of-network providers at emergency facilities. Emergency facilities include emergency departments at hospitals, freestanding emergency departments, and they can also include urgent care centers if those urgent care centers fit the definition of a freestanding emergency room. Some urgent care centers are more like walk-in family practices. Some are more set up like freestanding emergency rooms. So you need to know, if you are an urgent care practice, what category you fall into, if you have any out-of-network providers at your facility. So there is also no balance billing for certain non-emergency services by out-of-network providers at certain in-network facilities. Okay, we're going to get into this a little bit more, but a lot of this will be applicable to services related to the emergency care. And we're also going to see a flat out prohibition on balance billing for ancillary services at surgical centers. That's probably the most significant way that this is going to affect ambulatory surgical centers. Okay, and there's no balance billing for out-of-network air ambulance providers. I am going to assume, as I have with the last few presentations I did on this topic, that we do not have a large population of air ambulance providers on the call. So again, I'm not going to spend a lot of time focusing on that, assuming that air ambulance providers have hopefully consulted with counsel. But just be aware, if you ever have a patient that requires that type of service, that this bill can affect that, and whether or not they can be billed. So what exactly counts as an emergency service? Okay, so any service that is provided to a patient who presents to an emergency facility seeking emergency care for a condition that a reasonable layperson would think is an emergency. Okay, that is critical. All right, it's not something that a doctor has to realize is an emergency. It's not something that a triage nurse has to realize is an emergency. And it's quite frankly not something that really has to actually be a true clinical emergency. However, if the reasonable layperson would think it was an emergency, that is an emergency service. All right, so what does this mean? This means that the framers of this bill did not want to put emergency departments and emergency rooms in a situation where people would just start going to the emergency room for all of their routine care and all of their routine illnesses because, hey, I can't be billed now, right? So there was at least a little bit of forethought into that. For those of you who don't know, I am general counsel for New Jersey Emergency Physicians, and I'm also general counsel for the New Jersey Emergency Nurses. So emergency providers and physicians and emergency departments are very near and dear to my heart. I work with you guys daily, and I know that that is a huge problem in EDs, people who are uninsured or underinsured using EDs for their routine care. So if a reasonable layperson would not think that whatever this person is presenting to your ED with is an emergency, then this law does not protect that individual from getting balance billed by out-of-network providers for the services they received. It also does not protect someone who is uninsured for getting billed for the services they received. Okay, what else is an emergency service? Remember how I said some services that are related to the emergency service are also included? Any services available to help determine if an emergency exists are considered part of those emergency services, and you cannot balance bill for them. So that means if, again, you have an out-of-network, the orthopedist on call that night is out of network, okay, and they come in and they see a patient and they determine, yes, they have an emergency condition. Even if they determine no, they don't have an emergency condition, they cannot balance bill. They are only getting reimbursed the in-network rate for whatever third-party payer that patient has. If the patient's uninsured, they cannot bill the patient at all. Okay. Post-stabilization services as part of outpatient observation or inpatient or outpatient stay, which are related to the emergency visit. You find that the person is suffering from an emergency condition and they need to be admitted to the hospital. Any and all services and treatment that that patient receives after they are admitted to the hospital, even if they're stable and the emergency condition is no longer an emergency, now it's just treatment and care, okay? Anything related to why they were admitted, that emergency condition that caused them to be an admitted patient, cannot be balance billed. If they develop a new condition, or if something else comes up that's not related to the emergency condition, that's fair game. Okay, that can be balance billed, that can be billed out of network, that can be billed to uninsured patients. But you have to be very careful with that as well. Okay, so as many of you may have heard, there is a consent and waiver exception. What does this mean, right? The consent and waiver exception means that in certain scenarios, you can provide your patient with a notice informing them of their rights, informing them of other various pertinent information, and they can then consent to be subject to your prices, to your fees, to your charges, and they can waive their protections under the No Surprise Bills Act. There are two important things to know about this. One, there are very specific requirements for what must be in a waiver and consent, how it must be taken, and how it must be obtained. And there are very specific scenarios in which you can and cannot get a waiver and consent. Okay, so let's start by talking about what needs to be in that waiver and consent. This has been the most significant concern for my clients right now. Most of my clients are in private practice. I have a significant portion of my clients who are out of network. And their biggest concern right now is getting set up with appropriate consents and waivers, okay? So what has to be included? Well, right now, we're not 100% sure as these consents and waivers start getting complained about, what kind of changes and updates we're gonna have to make. So to a certain extent, this is a bit of a fluid situation. However, we do have very good guidance right from the statute and right from the regulations that were drafted as a result of the statute, telling us what we need to have in there. Where we're going to see growth and change probably over the next 6 to 12 months is in interpretation of how these things have to be included in the areas where the statute and the regulations are not totally clear. Okay, so what is clear? All right, the consent and waiver must have the patient's name. It must have the provider's name. Now, the provider's name doesn't mean, hey, this is just the name of the practice and you're going to see one of our 5 physicians or one of our 5 providers, okay? The provider's name means the exact individual provider who that patient will be seeing, all right? You can certainly have a consent and waiver that just lists all of the providers in your facility. That is perfectly acceptable. However, there has to be a way for the patient to indicate the specific providers for whom they are consenting and waiving their protections. It can't just be blanket for anyone in the practice. And if they see someone in the practice who they did not specifically consent, then you can't balance bill them for that provider. Okay, there has to be a statement that the provider is out of network. And you do have to, that statement does have to include a brief summary of what that means to the patient. You have to assume that the typical patient is not sophisticated enough to understand what out of network means, and that out of network means that they could have a significant financial burden that their insurance is not going to cover. Okay, you also have to include a good faith estimate of the amount the patient may be charged. This is the most complicated piece. We're going to get back to it, I promise you. We're going to get back to that and we're going to go over it in more detail. You have to also have a statement that prior authorization forms or other managed care limitations may apply. So what does this mean? This means a patient's coming to see you, they're choosing to see you out of network. They do not want to see the in-network provider that is available to them. And they say, that's fine, I'm just going to submit to my insurance and whatever I get back, I get back. You need to inform your patient that, you know what, if you don't also get a prior authorization for my services, you may get nothing back. You also may be limited as to how you can obtain services such as mine. Okay, so you have to have a statement to that effect in the consent and waiver as well. If you have a facility, okay, so this is for my ambulatory surgical center people who are on the call. You must include a list of in-network providers available at the same facility for the same services. Okay, so let's say, for example, you are an ambulatory surgical center and you have out-of-network anesthesiologists and you have in-network anesthesiologists. If your patient is presented with a consent and waiver to utilize the out-of-network anesthesiologist, that waiver must also list the name or names of the in-network anesthesiologists also who have privileges at the facility who can provide the same services. Okay, so what is a good faith estimate? I promised you that we would get back to this. This has been the most complicated part. And at this point, we really are going on guidance from the regulations, guidance from advisory opinions, guidance from how this has been interpreted before. A good faith estimate should include pricing for the initial service, and then pricing for any ancillary services, plus pricing for any services that may be required for continuing care. So what does this mean? Okay, I'm going to give you a couple examples. One example is, you're going to an ambulatory surgical center for a minor procedure, and you have to come back to that same ambulatory surgical center in 2 weeks for a follow-up visit. So your good faith estimate needs to include pricing for the procedure, pricing for any and all ancillary services that are going to be required as part of that procedure, and pricing for that follow-up visit. Okay. Ancillary services, what does that mean? That's your laboratory services. Okay. If you use an out-of-network laboratory, if you have an out-of-network radiologist reading films, if you, again, the out-of-network anesthesiologist, all of those things that are part and parcel of a ambulatory surgical center visit for a procedure. These are all things that need to be included. Now, again, I'm going to tell you, we're going to get back to ancillary services at ambulatory surgical centers because there are very specific rules that apply to those. And in a minute, what I tell you about that is going to make you realize that even if you include ancillary services as an ambulatory surgical center, you're not going to be able to balance bill for them. So the inclusion of pricing for ancillary services, that's really something that's critical for my medical practice individuals who are on the call today. If you are with an ambulatory surgical center, we're going to learn that as far as ambulatory services are concerned, you better be getting a lot of people who are in network on board very soon. Okay. So when do these consents need to be provided? They need to be provided at least 3 days prior to the patient's appointment. If the patient books with you fewer than 3 days prior to their appointment, then they have to be provided as soon as the appointment is booked, but in any event, no fewer than 3 hours before the appointment time. Okay, they can be provided electronically. If the patient wants them on paper, they have to be provided on paper, but you do have to provide them within these advanced time frames. This is probably the biggest burden that practices are going to have. Once you have these documents established, once they're ready to go, that burden is pretty much over. The biggest burden going forward, in my opinion, is going to be getting these documents out to your new patients and patients who need new services in the prescriptive timeframes. And keep in mind, you can't just email them to them unless you're using an encrypted email system. Okay, so this is really where your patient portals are going to come in handy rather, and making sure you're really utilizing those patient portals and having your patients utilize those patient portals. This is going to become very important. How do the documents need to be provided? Okay, as I said, at the patient's preference, they need to be provided electronically or on paper. Most patients are going to ask for them electronically, but there are certain patients that we do see in certain patient populations who still prefer paper. And if they ask for that, you have to provide them in that way. The document has to be a separate form. It can be in your general intake packet, but it must be a completely separate form. It cannot be combined with any other consents. It cannot be combined with any other intake forms. If you have a financial agreement form, keep that, okay? Still have your patients fill that out because a consent and waiver is not a financial agreement. But you also still have to have the consent and waiver form, and that has to be a completely separate form. The reason for that and the public policy reason behind that is that you don't want somebody thinking that they have to consent to that because they need to consent to something else. You also don't want them overwhelmed by all of the things they're consenting to on the same page. It really needs to be a completely separate, standalone document that's easily readable and understandable by your typical patient. Okay, what if a patient says, I'm not signing this. I'm not waiving my consent, or I'm not consenting to waive my protections under this act. Forget you. I'm going to get your out-of-network services and you're only going to get paid in network, and too bad. You can refuse to treat that patient. Okay, what a lot of people, well, except unless you're in an emergency department. And again, in the emergency department, we can't even give these forms. So if you're in a practice environment where consent and waivers are appropriate and you are utilizing them for your patients, and you have a new patient come in, or you have an existing patient who needs new services, and they say, I am not signing this, you're just going to take whatever my insurance pays you and like it because now I have these protections, you can absolutely refuse to treat that patient. I think what a lot of my physician and provider clients forget is that for all of the bad reasons that you're a private business, this is one of the good reasons you're a private business. You are a private practice. The word private is right in there. You do not have to treat every patient that walks through your door. So long as you are not refusing to treat patients based on a protected class, you can refuse to treat patients. And refusing to sign any kind of consent is not a protected class, okay? The same way that if a patient refuses to sign an informed consent for treatment, you don't have to treat them. And I'd say you shouldn't treat them. What's very important to understand is if you do not comply with even one requirement of this act, you cannot balance bill, and you can be fined and penalized if you do balance bill. So it's very important that you're meticulous, that you're doing absolutely everything, and you're not missing any steps. Because if you miss even one step, even if you're doing 99% of it correctly, you cannot balance bill, a patient can complain, and you can get fined and penalized for that under the law. The other important thing to note is that a patient can revoke their consent and waiver prior to treatment. However, this consent, the revocation has to be in writing. They can't simply say, you know, as you're pushing the anesthesia, just kidding, I revoke my consent and waiver to be covered by the No Surprise Bills Act. Haha, go ahead, give me my surgery. They can't do that. They do have to revoke it in writing, okay? And that's a good protection that was put in there because there are a lot of other documents that patients can just revoke orally at the last minute. Okay, so what else do we need to know about our good faith estimate forms? Which, just so you know, I am using good faith estimate form interchangeably with consent and waiver. So your consent and waiver is your good faith estimate. You are giving the client, or the patient rather, a good faith estimate, and you are asking them, once they have reviewed that good faith estimate, to consent to it and waive their protections under the No Surprise Bills Act. So when you see me talking about a good faith estimate or a consent and waiver, I am using those terms interchangeably. They mean the same document. So the good faith estimate, your consent and waiver, has to be available in the 15 most common languages spoken in your service area. Okay, State Department of Health will help you figure that out. And there are services that will interpret the document for you. This is why I think it's very important to make sure that you have a compliant document that can be utilized, you know, with several blanks that can be filled in to conform to the situation, because you're going to have to get it interpreted into 15 different languages. And you can't just wait until you have a patient that needs that language. You have to have all 15 languages available. I foresee a situation in which there will be random audits and random checks to determine if there is compliance with this bill. Okay, because any federal laws where the federal government gets to fine you and take some money if you're not doing things right, there are always random audits and random checks to make sure you're doing what you're supposed to be doing. So you must have that document pulled together and it must be available in the 15 most common languages spoken in the practice or ambulatory surgical centers service area. In New York and New Jersey, we can very easily have people with 15 different languages coming into any one of our offices on any given day. So in an area like this, I do think that's critically important. It's something that you, as a public policy, you should probably have anyway. But under this particular law, it's going to be required. If the patient speaks a different language than one of those 15, then an interpreter does need to be provided by the practice. And the same way that you cannot charge patients for interpreters if they need one ordinarily, you cannot charge a patient for an interpreter for this. The forms have to include the time and date the patient got the notice, as well as the time and date the patient signed. Now, does the patient have to sign when they get the notice? No, they don't. But the time and date they got the notice has to be on there, and the time and date that they signed has to be on there. So they can sign everything when they come in, but there has to be something on there indicating that they had that 3-day to 3-hour lead time, depending on what the applicable situation is. And when they sign, they're signing to acknowledge that they had that time. Okay, so for my ambulatory surgical center friends who are on the call today, here is the most important thing you need to know. And yes, I've said a lot of really important things so far. Ancillary services at ASCs are always subject to balance billing prohibitions. Okay, ambulatory surgical centers can never balance bill for ancillary services. Patients cannot consent to and waive the balance billing protections for ancillary services. I know this is going to be huge for a lot of ambulatory surgical centers. I know this means that you may have to change laboratories, you may have to change who you use for pathology, you may have to get new anesthesia providers, what have you. But unfortunately, this is what we have, okay? And the public policy basis for this is that your patient has chosen you and your ambulatory surgical center. They have absolutely no control over the providers of the ancillary services. If they have no control over picking the providers of the ancillary services, you or those ancillary service providers absolutely cannot balance bill them because they did not have the choice of who they wanted to use. Okay, so what are ancillary services? I've alluded to what some of them are already, but let's get the actual list right from the horse's mouth. Ancillary services are items and services that are related to emergency medicine, anesthesiology, pathology, radiology, neonatology, okay, that are provided by either a physician or a non-physician practitioner. These are also items and services provided by assistant surgeons, hospitalists, and intensivists. Any kind of diagnostic services like radiology or lab services. And then items and services provided by an out-of-network provider when there is no in-network provider who can provide the same service, okay? Again, the simple example of this is you have an ambulatory surgical center, your center's in network, you as the surgeon, you're in network, but your anesthesia group is out of network. Well, your anesthesia group is out of luck unless you have an in-network anesthesiologist that your patient can pick. Okay, your anesthesia group is now only getting reimbursed at the in-network rate for the patients that they treat at your facility. Okay, so what happens if you decide to go out of network when you are already caring for in-network patients? This actually is something that happens a lot. People decide to go out of network with certain payers for many reasons at any given point in time. If you go out of network while you are already caring for in-network patients, these are individuals who need your continuity of care, You have to accept payment from the plan issuer for up to 90 days after the patient has been notified that you're going out of network. Okay, many of you probably already know, and if you don't, your PAR agreements, your participation agreements with your providers will typically require a 30 or a 60-day continuity of care provision. However, what's really important about this is now it's 90 days across the board. I don't care what your agreements with the plans say that you're participating with. And you have to accept the in-network payment. You can't say to a patient, I'm going out of network in 30 days, and oh, here's your good faith estimate. You have to start paying me in 30 days. Okay, that consent and waiver is not going to be enforceable. And you're very likely going to get a complaint filed against you by that patient. All right, you also have to have a posted notice. My clients who know me and who have worked with me, hear me joke all the time that now whenever I go to the doctor, I look around and I make sure that they've wallpapered their waiting rooms appropriately with all of the notices that they have to give to their patients. Well, here's another one, okay? I wanna put this right out there though, that this law absolutely does not require you to put your prices on your website. I had a couple clients call me at the very beginning saying that that was a rumor that was going around certain circles, that certain people were telling them this was the case. That is not the case. This law does not generate any requirement to put prices on your website. Now, I will say there's a caveat there that there may be some other laws that apply to you or your type of facility that may require that. This law does not require that. So your typical medical practice, your typical ambulatory surgical center, this law is not requiring that you put prices on the website. You do have to post a notice to the patients that they have legal protections against balance billing. Okay, there are sample notices available at no charge on the federal government CMS website. You also may want to conform the notice a little bit to your own situation. I found the sample notices are a little bit lacking, and I've been developing notices that I feel are a little clearer and a little more appropriate for my medical practice clients. And there's really strict requirements. It has to be in 12-point font. You have to try to limit it to in length, okay? Once you have this notice established, you have to post it in your office, okay? It doesn't say where in the office, but I always say the waiting room because I find that that's gonna be the most compliant place. It also has to be on your website, and it has to be somehow accessible on the homepage of your website. It does not have to be in its totality on the homepage, but it does have to be either on the homepage or linked to on the homepage. You cannot require a patient to give you any kind of information like an email address or register, anything like that to access it. You cannot only have it behind a paywall or behind a patient portal. It must be accessible to anyone of the general public who wants to pull up your website and see if you have that notice. Again, my experience with HIPAA and random HIPAA audits tells me that this will be the vehicle that the federal government is using to determine who they are going to randomly audit for compliance with this law. So if you don't have this notice done and it's not on your website, I do think that's your highest priority right now. You also have to have the notice in your consent and waiver or with your consent and waiver. Okay. So what happens when the balance billing prohibition applies? Okay, if there's no state law that controls or no all payer model agreement applicable, then the out-of-network provider can accept the initial payment from the third-party payer, or you can enter into a 30-day open negotiations period with that third-party payer to negotiate your payment. Okay, basically that means that you can negotiate with them, but the negotiations have to be resolved in 30 days, or else you can move on to the next step of your remedies. This prevents third-party payers from simply ignoring you or, attempting to keep you in endless negotiations and just never pay you unless you accept what they want to give you. If those negotiations fail in that 30-day period, then the provider can elect to enter into an independent dispute resolution process, abbreviated IDR, with the payer. You cannot at all in any way involve your patient in the negotiations or the IDR. Now, I don't know what's going to happen with IDR. We already have one court case that just came across the wire saying that one state court has already shot down IDR as inappropriate, this IDR process. So if we talk again in 3 or 6 months, there may be a different process. They may have to amend this bill, depending on how the courts interpret it. That's why you'll remember I said at the top, this is going to somewhat be an evolving process this year when we start to see advisory opinions come down and opinions on complaints come down. So already this IDR process is questionable, but it's still there. Okay, and until it's completely shot down and the courts say to the federal government, go back and change this, and we get something that's new, it's still there and you have to be aware of it. However, just based on what we're seeing happening in the courts already, I don't think the IDR is going to last. I think we're going to have something new probably within the year. Okay, when the balance billing prohibition applies. If you are out of network, you are completely responsible for determining if each and every facility at which you work, at which you provide services, is in network for each patient. It is not the facility's responsibility to find out for you. It is not the facility's responsibility to affirmatively tell you. It's not the facility's responsibility to get you your consent and waiver. The facilities may choose to do this for you as a courtesy, but they don't have to, and it's not their responsibility. I think that a smart facility would probably work with their out-of-network providers. But again, just be aware that they don't have to. And a lot of your larger hospital systems probably won't. So it is going to be on you. It's going to be your responsibility to determine if the facilities you're at are in network for each and every patient that you treat at those facilities. Even if you so much as accidentally send a bill to a patient you shouldn't be billing, you have violated the law. I don't care if the second the patient calls you and says, hey, I got a bill by mistake, and you say, oh, I'm so sorry, rip it up. That was a complete mistake, rip it up. You've already violated the law, you can be fined for doing that, okay? So make sure that your biller, make sure that whoever you're using for billing and coding, if you're not using Pinky, we have someone wonderful and lovely right here who will make sure you're compliant with everything. Make sure whoever you're using knows that there's no room for error here, okay? Even an error that you realize is an error and that person never has to pay you, and everyone agrees they don't have to pay you, is a violation of the law. So you really have to be on top of this. How do patients complain? I love this, right? When I do presentations about state bar association or state board, rather, I'm sorry, for me, it's a state bar, for you, it's a state board. When I do presentations about state board, things like that, what I love is that everything is just one-click complaint now. It's like the Yelp of professional services. Instead of going and putting a bad review, which people may also do, that's a different lecture, how to deal with online reviews as a medical provider. Patients can file complaints with the click of a mouse, okay? And that is right there where you can submit a complaint. The good thing is that providers can also submit complaints, okay? So if you think a third-party payer is not playing by the rules, you can also submit complaints about them. So that's one of the things I really like about this bill. It empowers the third party, or rather it empowers the providers who are playing by the rules to also report third party payers who they believe are not. So I definitely encourage everybody to take a look at that website. And we are almost at time. I spoke a little bit faster than I thought I would, but I do see lots of good questions coming in the chat and the Q&A. So please just take a moment. I'm going to keep this up here. This is all of my contact information. Pinky knows this. If anybody on the call knows me, you all know this as well. But please, I'm more than happy to answer any questions you have. Today, I do have a hard stop at 11:30. I do have a hard stop at 11:30 today, but if we don't get through all the questions or you have additional questions or a private question you'd like to ask, please don't hesitate to reach out to me anytime.
That was an amazing presentation, Gina.
Thank you.
Amazing. So Jean, do you want to take the Q&A?
I was going to say I have
Yeah.
the Q&A open here.
Go ahead, please. Thank
So I'll
you.
start. So the first question I have here is, what would incentivize a patient to sign a waiver? That's a really good question. And it's a question I'm getting from a lot of people. Well, why is a patient going to sign a consent and waiver to pay more for out-of-network services when they could potentially find in-network services? And I'm finding that this is mostly applicable to my physicians and providers who are in fields that are very commonly out of network. So I think that many patients will be incentivized to sign these waivers because they want to see their provider. They don't want to have to find someone new who's in network, and they've already been paying the out-of-network fees, and they've already been submitting on their own and just getting back whatever their insurance will give them. So I don't necessarily think that this is going to have a major chilling effect on people visiting out-of-network providers. I do think where it's going to have a chilling effect is when people have a choice for an ancillary provider that they already don't know between in-network and out-of-network. I think in that scenario, you're going to have many, many people knowingly choosing the in-network ancillary provider over the out-of-network. But I do think it's just the relationship people have with their providers. In a lot of situations, people are already knowingly choosing an out-of-network provider. And a lot of the private out-of-network providers, these are fields where almost everyone is out of network. So I think wanting to go to the provider or physician you want is the incentive to sign. Okay, so the next question is, signing consents at least 3 days before. Okay, what is the maximum amount of days patients can sign? There is no maximum amount of days. And well, let me rephrase that. The maximum amount of days is a year, okay? So there is no maximum amount of days in the common sense that if a patient signs it 30 days before or 60 days before they first come see you, the longest time period in which a consent and waiver is valid is 1 year. Okay, so, and this is something that we're still learning as the advisory opinions come down. But for one of the most difficult problems is you do have to include all potential support services in continuing care. So right now, for example, psychologists who foresee continuing care for the next year, and it could potentially be quite shockingly expensive when you annualize 1 or 2 visits a week over the course of a year. That's a problem we're having right now. And that's something we're seeking guidance and clarification from CMS about and from the Department of Health about, because there is a concern that this will have a significant chilling effect on people seeking mental health care when they see what it's going to actually cost them over a year rather than a month at a time or a couple of weeks at a time. So the maximum time period is a year. And what most providers are doing is just saying, hey, this is what it could potentially cost you to see me this year, and we'll have you sign another one next year. And in most scenarios, I think that's a good idea. I think that works. But like I said, for a lot of my clients in the mental health space, I have personally reached out to seek guidance and clarification on the continuing care piece because there is a huge fear of a chilling effect providing a year of annualized services for mental health. Okay, next question. Who decides if a patient was being reasonable in thinking the services were an emergency? If a patient, this is the typical legal reasonable person standard. If 5 people off the street would think, yeah, that's an emergency, it's an emergency. It's kind of a smell test, right? It's not, and you don't take the person as they are, right? So if you have a hypochondriac that thinks a paper cut's an emergency, they're not a reasonable person. A reasonable person would not think a paper cut was an emergency. If you have someone with chest pains who reasonably believes they're having a heart attack, but then after everything you find out it was just really bad gas or something like that, they reasonably believe they were having an emergency, even though it wasn't. So this is kind of like the pornography standard. You know it when you see it. There isn't really a hard and fast standard there. Okay, a next question. Does this act apply to a physician group who only sees patients in office and does not provide services in facilities? Yes, it does. And that's one of the biggest questions I'm getting. I do not see patients in facilities. This doesn't apply to me. No, that is incorrect. That is an incorrect interpretation of the law. If you see patients out of network, if you see patients cash pay, if you see patients who are uninsured cash pay, this law applies to you and you must be compliant with it. What is the next question? What is the impact on nurse practitioner or physician assistants billing reimbursement in the emergency room? That's a great question. They would be considered ancillary services in the emergency room. And if they're contracted to provide services to the hospital with a private group, and that group is out of network, there's a complete prohibition on balance billing. So I think really what we're going to see here is a lot more, if there were any emergency services groups that were staffing EDs that were still out of network, we are going to see them moving towards all going in network now. Question is, thank you for the information. Are the slides of this presentation going to be available for us to review? I know that Pinky is going to be sending something out, or I will be sending something as a summary when we're done. And I'm certainly happy to include the slides so you guys can take a look at those. And that
Gina,
was a question as well.
Yeah,
Yes,
Jane,
Pinky.
I'm sorry. I think this one is a very important. 2 questions. It's on the chat, but it's not on the Q&A.
Oh,
So
I was
one
going to
is-
go to that next.
Okay,
Yeah.
go ahead. Please go ahead.
Yeah, I was going to go through
HCs and the
Q&A.
urgent care. Yeah. Go ahead.
I was going to finish. No problem. I was going to the chat. I promise. I didn't miss that.
Very good. Thank you.
All right. So how does this impact an ASC that is owned by a parent company that also owns the medical group where both facility and physician from group are in network with the same plans? There will be no instances where the patient is in with the facility and out with the physician anesthesia lab. Okay, so if everyone's in network, everyone's in network, okay? You don't have to worry about it. Your patient's in network with your facility, they're in network with your physicians, they're in network with your providers, they're in network with your ancillaries. Great, you can go to bed tonight and you don't have to worry about this law. So that is really the best type of situation for an ASC really to be in under this law. Does durable medical equipment fall under ancillary? Would the No Surprise Act limit what a clinic or DME provider can charge for a product? What would dictate price? MSRP, manufacturer suggested retail price, or the in-network reimbursement rates? Okay, so yes, DME is very likely going to fall under ancillary. And the No Surprise Act is going to limit, if this is something that is prescriptive and can be, billed by insurance, you are going to have limits. You are going to be affected by this law, and the price is going to be dictated typically by reimbursement rates for whatever. There's multiple answers if we pick this one apart. So there really is no one answer, but I'm going to try to give the most general answer. So yes, in most cases it applies. If you are in network, but your DME supplier is out of network, then reimbursement rates for your patient and their third-party payer is going to dictate pricing. However, if you are a practice with DME, then your patients can sign a consent and waiver. If you're an ASC with DME, they can't. So the individual who asked that question, that may be something for us to talk about offline a little bit more specifically and get some more details. Okay, so the next question. Some patients choose not to go through their insurances due to privacy. How do we bill those? Okay, so I'm going to assume here that you are in network, but the patients just want to cash pay because they don't want an EOB going to a parent or a spouse or what have you. You're going to treat those patients as if they were uninsured cash pay patients. They do have to sign a consent and waiver in that situation. For a private practice where all of providers are out of network, I am assuming this rule does not apply. No, that's totally incorrect. The rule does apply. The rule applies. Yes, if you are a private practice and everyone is out of network, the rule 100% applies to you. You have to have all of this implemented, and every single patient that comes to see you needs to be signing a consent and waiver.
You're more at risk.
Yeah, you're significantly at risk. So you do need to get yourself on board with that. Okay, now I'm going over to the chat. All right, here we go. All right, so this question says, you will probably cover, I hope I did. You will probably cover the first part of my question, which is what are the patient's remedies for non-compliance? Okay, so yes, the patients can complain about you, and then CME or Department of Health will investigate, and you can potentially be subject to penalties and fines. Second part is whether a violation of the No Surprise Act could subject the practitioner to treble damages and attorney's fees under the FTC acts that some states have, such as the Connecticut Unfair Trade Practices Act. That's something I would need to look into specifically. If you specifically have a question, I am not licensed in Connecticut, but if you specifically have a question about specific state laws, please feel free, and how they interplay with this, please feel free to reach out to me. To the extent I can provide you with information or guidance, I'm happy to. And to the extent I need to connect you with local counsel to help you, I'm also happy to do that as well. This is an excellent question. I'm sorry I can't provide a comprehensive answer for you, but I think this really highlights why it's incredibly important to know how the No Surprise Act correlates to your state laws. If you do have state laws that are more restrictive or could now suddenly impose even more penalties on you for violating the No Surprise Act, you need to know that, you need to be aware of that. And, consulting with counsel and your local health counsel is the best way to do that. So please, the person who asked this question, reach out to me. And like I said, if we need to get you hooked up with local Connecticut counsel, I'm happy to do that. Next question, does it apply to laboratories, molecular testing? Yes, it does. And if you have patients coming to your lab directly, they get to choose which laboratory they come to. Then you need to have them signing the consent and waiver. If you are providing ancillary services for an ambulatory surgical center or a hospital, you cannot balance bill out of network patients. You just cannot. So this is actually going to have a huge effect on laboratories that I think a lot of laboratories aren't even realizing yet. But a lot of laboratories who do primarily ancillary services are really going to have no choice but to go in network, or have a very, very strong advocate working on their behalf to negotiate the out-of-network rates they're going to get from third-party payers. Okay. The next question was, if an appointment is booked less than 3 days, is there still a requirement to supply the GFE? Yes, you have to supply the GFE at least 3 days in advance. However, if a patient books with you fewer than 3 days in advance, they have to get it at least 3 hours before the appointment. So, if they're coming in at noon, make sure they get it by 9 o'clock in the morning. And like I said, when they come in, you're going to have them sign off on what date and time they received it, as well as the date and time they signed. Any specifics for federally qualified health centers? That's another one that I'm going to ask the individual who asked that question to reach out to me directly so I can get more information. It's going to depend what kind of federally qualified health center you are. And that's something I would need to look at specifically for you, and I'm happy to do so. Right now, I was just focusing mainly on my general practice, private practices and private ASCs. So please reach out to me. I'm happy to look into that with you. Okay, we have a few more questions about the slides. Yes, like I said, I'm happy to share them. Okay, so this is a very good question. Does this affect, well, all the questions have been wonderful. Does this affect not covered cash services? And if so, what provisions can we take to keep compliant? Thank you. Okay, so if you're providing services that are not covered and are not paid for by insurance, then no, you do not have to supply a GFE. But you need to be very sure that they're not covered and they're not paid for by the insurance. And you also have to be very careful with how those not covered services interplay with any covered services that you may be providing. But no, if it is a service that is not covered and not paid for by insurance, then you do not have to supply a GFE. Okay. All right, next question. How does the 3-day, 3-hour rule apply to urgent care offices for same-day appointments and walk-ins? Okay, so remember we said that your first thing you need to figure out is, does your urgent care count as an emergency services location? Okay, so that's really the first thing you need to find out, if your urgent care is an emergency services location. And if it's set up like, if it's set up like a freestanding emergency room, it is very likely that it is going to be an emergency services location. And then you cannot ask patients for a consent and waiver. If you're a family practice urgent care or something like that, and you've determined that you do not qualify as a freestanding emergency facility, then what I would recommend is just have something in place where it says, if you plan to walk in, you have to review this, something like that. But I do think that's one of the things we're waiting for clarification on. I think the reason why we don't have clarification on that yet is because I suspect that many urgent care centers are going to be determined to be qualified as emergency facilities, which are not able to ask for a consent and waiver. Okay. Next question. Okay, can the physician group have a different cash price for self-pay than insured patients? Pinky, I'm actually going to let you answer this one. I'll repeat it. It was, can the physician group have a different cash price for self-pay than insured patients?
Where is that question again? I'm sorry.
It's in the chat. It's a question from the chat. Can a physician group have a different cash price?
Cash price and?
For self-pay rather than different than the price that they charge insured patients.
So when they are cash price, that means to say these are services that are not covered by the insurance company, right? So anything that is not
either if they're not covered, or I think the question here is if somebody just decides they want to pay cash and they don't want to go through their insurance, can you charge cash patients different price than what you bill to insurance?
Absolutely. Absolutely. So you can have different prices for the cash based, because I know I do a lot of pain management physicians that does services that, the drug may not be covered, or because it's overutilization, those kind of things. Yes, absolutely, you can, but you have to be very clear. The consent is just all about informed consent. Let your patient know this is what you're going to pay and this is what you'll be responsible for. Absolutely, you can.
Thank you, Pinky. I'm sorry, I didn't mean to take.
No, that's okay. Thank you so much. Thank you. Any questions like that, reimbursement, and how to set up this fee schedule and complying with this act, everyone, I can help you with this. Legally, I cannot, because Gina is really the authorized person to even speak with you about it. How to implement it in your practice, that I can come in. I can definitely help you. How to be,
and that's why, I always tell my clients, you have to have your team. You have to have your trusted team. And this is why even me, I have my counsel attorneys who are part of my trusted team. And then I have a group of people called my strategic partners, like Pinky. And these are people
Thank you.
I have no financial interest. They're simply people I've been working with for years, that I'm working with common clients for years. I trust them. I know that they're experts at what they do. And I try to help my clients build their team. So make sure you have a good team to help you, because this is not something you're going to be able to do on your own, and get your team working for you. Okay, so I have another question here, which the asker says, I apologize if this is convoluted. So I'm going to read it out loud and then see if we can get to the crux of it. If you are in a specialty in which you provide multiple services, including advanced images, office visits, physical therapy, in-office procedures, etc., and this is all based on a patient complaint, image review, and physical exam, I'd be concerned the estimate could potentially be dumbed down for what the initial services are. Do you need to give subsequent estimates as the treatment plans evolve over the course of the year? Okay, so this is, yes, and I thank you for the detail. If you're giving a good faith estimate for, okay, these are the initial services, I'm gonna see you, we're gonna do, and please, I'm not a clinician, so this is gonna be very like spot the dog, okay? Example for here. So if you say, okay, you hurt your ankle, we're gonna have you come in, we're gonna do an x-ray of your ankle, we're gonna find out what's wrong, and then we're gonna do physical therapy to help you with your ankle. That would be one good faith estimate, okay? If, let's say, like the third physical therapy appointment, the person twists their ankle again, falls over screaming, and you have to do more services, that's a new good faith estimate. So yes, the good faith estimate absolutely can and should evolve, because here's the kicker. If you charge your patient more than $400 over that good faith estimate, they do not have to pay you. So what I've been telling a lot of my clients is this: if you can overestimate, and that will not have a chilling effect on your patient, overestimate. And then if you end up providing fewer services or less expensive services, you do not have to provide a new good faith estimate. However, if you find that your patient needs a higher level of care than what you initially estimated, you absolutely should and have to issue a new good faith estimate. First of all, because that's the public policy of the bill and the law, but also because you could not get paid. Okay, so now you're providing an incredibly high specialized level of care to this patient. And if it's over $400 more than what you initially anticipated, they could say, sorry, so sad, not paying you. You didn't give me a new good faith estimate. And we all know how some patients can be incredibly grateful for all of your time and efforts on their behalf at the end of the day.
Gina, if I may add, Jean, this
Yes.
is just my recommendation. When you have this kind of practice, you have to assign one person to be your patient advocate. That could be an office manager, a finance person in your practice that could speak to your patient before they receive this service. That could explain this, and in writing, and they can sign these consent forms. I think it's really best, and it's more efficient in your workflow when you have one person who's going to be who will be assigned as a finance and at the same time a patient advocate that could explain this to them.
I agree completely, Pinky. Now, Pinky, we have a follow-up question to the one I asked you to answer. So I'm going to do this one to you again. What this individual says is, but if you have a lower cash price for a CPT code than what insurance pays, that will not affect your reimbursement globally. Insurance may reset your reimbursement for that code to the cash price. So I think the question here is, yes, you can have a different price for cash than what you bill insurance, but then risking insurance lowering your reimbursement.
You either you match it or you don't go lower than the allowable amount. It doesn't make sense. So you either match it with the allowable amount, right? Or you go 20% above, you go 30% above, because that is cash based,
Right.
But
right.
absolutely, you can have different fee schedule, but just be careful that the reason they're paying out of pocket because it's not covered, it's overutilization, it's not
Right.
authorized. The patient will say, you know what, my insurance doesn't cover it. Okay, I'll pay out of pocket. So it's up to
Right.
you. But absolutely, you can have your own fee schedule, but it's all about informed consent. But you should not go below the allowable amount because you will
Mhm.
lose money.
Yep, absolutely.
Absolutely.
And then the last, I don't see any other questions popping up. So we've made good time. That's great. Like I said, if anybody has, additional questions that you'd like to ask, please don't ever hesitate. I'm so sorry. I just realized I might have had the questions up there. Please don't hesitate to reach out to me directly. And Pinky, the one last question we had was if we're going to be offering the recording of the presentation. I know we are recording it. I would be happy to offer it. So are we going to have that available for people to come
Yes,
back?
absolutely. Yes, absolutely.
Okay.
We can give them a link where they can view this.
Perfect.
But Gina, Elaine is asking, are we going to do this in the future again? Absolutely.
Yes.
I'm going to ask Gina to do this again.
Yes, I would love to do it again. I have to tell you, one of the things I miss so much from COVID times, something I miss so much from the before times. I used to go out and provide complimentary lectures and educational sessions to physicians and provider groups all the time. I miss it terribly, and I truly enjoyed today. Thank you all for welcoming me into your computers. Thank you all for being so attentive and listening to the advice I have to give. And please, if you'd like to discuss more in depth or your specific scenario, I'm always happy to meet someone new.
Yeah. So if you will allow me, Gina. So everyone, on behalf of my company, Go Healthcare Practice Solutions, I am here to answer all your questions. I am not going to charge you one single dime. Ask me any questions about how to implement this. How can you be compliant with this act? However practice you are in, you may be an ASC, you may be a private practice, FQHCs. I've done all of those. So please reach out to me. Any questions, I'm going to answer. Any questions. Thank you so much for being here, guys. I hope this brought value to you. Gina, you are still awesome. Very brilliant.
Thank you so much. Thank you.
Thank you. Thank you so much. You take care. You can just end it, Jean. Thank you, everyone.
Oh, I'm sorry. I'm in the wrong place. There we go.
All right. Bye, Gina. Bye, everyone. Thank you.